Good afternoon, Ayush.
Good afternoon, sir.
How are you?
I'm good, sir.
Good. So, will you please give your brief introduction?
Sure, sir. So my name is Aayush. I graduated from Punjab University, Chandigarh in the year 2020. So after my graduation, I got the opportunity to serve Honorable Mr. Justice Sanjeev Khanna as his judicial law clerk cum research assistant. And sir, currently I am serving as law officer in Hindustan Petroleum Corporation Limited in marketing headquarters, Mumbai.
Okay. So, why you want to come to judiciary?
Sir,
You are
after
already law officer there.
yes. Sir, I realized that judiciary is such a job which will give me the opportunity to engage with the society directly. So, sir, I, being a compassionate human being and also being a lover of law, I realized that writing judgments and imparting justice would give me more professional satisfaction than any other job.
Mhm. And what about your family, parents, and siblings?
Yes. So my father retired from All India Radio. He was the director of All India Radio Batinda, and my sister is currently pursuing MBA from Germany.
Okay. And what about your mother?
My mother is a homemaker, sir.
Okay. Good. So, what do you feel that how your experience and your this qualification and other things will help you to become a very good judicial officer?
Yes, sir. Sir, I would start with my current job profile. Sir, currently I am handling a lot of arbitration matters. And because, sir, as an in-house counsel, we have to engage with a lot of lawyers. So, sir, one thing I realized is that all lawyers have very different styles. So I realized that when I become a judge, this will also help me in engaging with the lawyers and how to handle lawyers. Second is that I've got a lot of arbitration experience now. I have got to know the intricacies of the law of arbitration and how the practice and procedure works. And last but not the least is, sir, I've also worked as a law researcher to Justice Khanna. So I learned a lot of things from him. For example, how to be very industrious and laborious, and how to keep yourself updated even when you are a judge and busy with the files. So these are the things, sir, which I believe will help me in my profession as a judge.
Mhm. Why you have not chosen to be a very good advocate?
Sir, I would be very honest that I started off in my career to be a lawyer. I joined a chamber, but sir, unfortunately, due to COVID, sir, the chamber could not retain me. But sir, then because I got the opportunity to serve as a law researcher and then life took a different turn, sir, I realize now that sir, it all happened for the good because sir, being a judge would really inspires me more than being an advocate. Because sir, for being an advocate, you are only contesting for one party, whereas being a judge, you are looking the public interest at large. So that is a much more opportunity of much more responsibility than being a lawyer.
Mhm. So, what is your area of interest, more interest?
Sir, arbitration law, CPC, these are some of the areas that I like.
Mhm. Whether the orders passed in arbitration are final or is it challengeable?
Sir, there is a list of certain orders that can be challenged. Not all orders can be challenged. So, for example, if a particular application is made before the arbitral tribunal for interim order under Section 17, sir, that is challengeable before the court. Otherwise, sir, also the arbitral award that is passed by the arbitral tribunal can be challenged to be set aside under Section 34, but not all orders, sir.
Is it arbitrator or is it arbitrate tribunal?
Sir,
You just
the
now mentioned arbitrate tribunal.
Yes, sir. Sir, the tribunal comprises of the authority which passes order, whereas, sir, an arbitrator is the person who is uh, presiding over the entire proceeding.
Mhm. How you uh, feel that what reforms can be brought down in the Indian judiciary system?
Sir, in Indian
Now,
judiciary,
earlier senior is the Chief Justice of India, Honorable Justice Sanjeev Khanna ji. So what you feel that requires to do reforms in Indian judiciary system, both are using artificial intelligence and electronic this thing, and otherwise also.
Yes. Sir, the primary focus should be on the fact that, sir, in judiciary we have a lot of vacancies. For example, recently the Honorable Supreme Court stated that Allahabad High Court has 160 sanctioned strength, but only 84 judges are there. So therefore, sir, 50% almost vacancies are pending. And sir, given the fact that now the cases have risen to 5.5 crores, sir, vacancies is first and foremost, which has always been stated by the Supreme Court. Second is, sir, also there is better funding can be done. Sir, certain district judiciaries, as our former Chief Justice has also stated, that, sir, women do not feel an equal participant in the judicial process because basic amenities such as toilets and creche in a courtroom facility for their babies, infants is not available. So better infrastructure, better staff, even for the judges. Sir, third is that recently the central government has approved 54 crores for artificial intelligence. Sir, it is true. I was listening to one of the speeches of the judges of the High Court, which stated that there is a lot of difficulty in knowing what is the latest precedent, for example, as to a particular matter. The judge incorporated a particular precedent only to a realization that that precedent has been overruled by another precedent just passed 1 week ago. So, sir, I believe that artificial intelligence can assist judges in drafting judgments, in legal research, and also lawyers to keep updated with the best practices.
Okay. In your opinion, whether the transparency in judiciary will be more effective if the streaming of court proceedings are there?
Sir, it has its pros and cons. Sir, though transparency will be increased, but sir, the courts are always have been an open court in India. Provisions of CRPC and CPC always mention that we are open courts. So streaming has both its pros and cons. Yes, it increases accountability and transparency, but above that, sir, also there is a reason, there's a scope of getting misconceived or misinterpreted by people who are not associated with litigation. Uh, Things can be taken out of context. We see that the judges are usually quoted on a particular fact in isolation. I personally feel and sympathize with the judges because if we read the entire, observation, the judge might not have said something like that, which is coming out differently. So therefore, sir, it has pros and cons, and facts to facts, it will be seen whether it's a boon or a bane.
You just mentioned that 5.5 crore cases are pending. Whether the fast track courts and family courts are not helping in reducing number of cases?
Sir, the fact being that the very intention and objective of these courts was to establish dedicated courts with fast track procedures. But, sir, due to certain reasons, sir, the dockets of even these courts have clogged. So, therefore, there needs to be an introspection as to why that has happened.
Okay. You see, recently the Calcutta case, which has been, judgment has come within 7-8 months. Whether it is because of fast track court or whether it was a public pressure and political pressure on the judge to deliver the judgment.
Sir, thank you, sir. So, sir, in cases with public pressure, we usually see that, sir, not only the trial takes faster, even the investigation takes faster. Sir, one example is the RG Kaur hospital medical case where, sir, there was too much pressure on the government and too much pressure even on the judiciary and also on the investigation team. They ultimately they caught the culprits within time. And sir, but sir, this is an exception. In most of the cases, we see that the investigation itself keeps on lingering. The recording of evidence also takes time. So, sir, I believe that even though there are timelines in CRPC, but sir, majority of them are directory in nature, and public pressure does play a role when it comes to such cases.
See, though the POSCO law is there and other stringent laws are there, even then the rape and other type of crimes are being taking place every day. In your opinion, how many percentage of the rape cases are being reported through FIR and other things?
Sir, I have read certain articles which mentions that given the fact in the Indian context where the victim feels that she will be stigmatized even more if she lodges a formal complaint, and she will be rather banished from the society because of the tag that will be attached to upon her. A lot of cases go underreported, especially in POXO matters, sir, because the offender sometimes is the near relative of the victim itself. Therefore, even the parents sometimes, given the fact that POXO has very stringent punishments, sir, they do not go ahead and lodge complaints. So, sir, there a lot of cases go underreported.
How much, in your opinion, percentage maybe it is?
Sir, I have not read any fact, any record with regard to it. So I would, sir, update myself after the interview with regard to the percentage.
And do you have idea that what is the structure of Indian judiciary system?
Yes, sir. Sir, we have the three courts at the outset, be it the Supreme Court, the High Court, and the District Judiciary. In District Judiciary, sir, we have further classification of criminal side and the civil side. In civil side, we have the Civil Judge Junior Division, Civil Judge Senior Division, Additional District Judge, and District Judge. At the criminal side, we have the Judicial Magistrate of second class, Judicial Magistrate of the first class, Chief Judicial Magistrate, Additional Sessions Judge, and Sessions Judge.
How do you feel that reforms will affect? I asked you regarding artificial use of artificial intelligence and other, though passports are there, everything is there, but still number of cases are increasing day by day, both in Supreme Court as well as in high courts and lower courts. So once you become the judge, whether you will be able to deliver the justice as well as reduce the pendency? I want very brief answer.
Sir, I will be working on my matters very diligently. I understand that, sir, it's a collective measure that needs to be taken, but I assure that I will be doing my job very diligently.
Any 2 or 3 important judgments of Supreme Court, recent judgments?
Sir, any judgment with regard to any matter?
Important judgments.
Important judgments. So the first judgment that comes to my mind is state of state of Punjab versus Devinder Singh, which is with regard to sub-classifications of scheduled caste and scheduled tribe, that whether scheduled caste is a homogeneous group or whether there can be a sub-classification. So that was an important judgment. Second is, sir, with regard to the judgment with regard to Section 12, subsection 5 of the Arbitration Act, that whether can a public sector undertaking compel the private contractor to choose an arbitrator from its curated panel or not. So these are the two judgments that come to my mind.
Anything regarding Bilkis Bano case?
Sir, Bilkis Bano, yes, sir. Sir, the judgment is with regard to, sir, whether the commutation of sentence that was granted, the remission of sentence that was granted, whether that was constitutional or not. So that was with regard to the fact that the trial took place in the state of Maharashtra, not in the state of Gujarat, because so the trial was transferred because of pressure. Therefore, the question was, can the state of Gujarat could have commuted the sentence? So the division bench answered in the negative, stated that because the trial took place in the state of Maharashtra, the commutation also should have been granted by state of Maharashtra, and the state of Gujarat had no authority over it.
Yes, Mr. Saket, please.
Hello, Aayush. So, Aayush, are you originally from Punjab?
Yes, sir.
Then why not Punjab Judiciary?
Sir, I like Delhi much more than Punjab. Actually, sir, I worked here for a while. And sir, I like the city, the culture of and the exposure of the city much more than the state of Punjab. So, sir, I prefer Delhi.
Because of city, you are choosing Delhi Judiciary.
Sir, Delhi Judiciary, yes, city is one of the major factors. Also, sir, professional exposure that Delhi offers is much more competitive than other judiciaries.
Okay, so you don't feel that you being a future good judge would, understand the problems better where you have grown up, because you are the state of your birth, that is Punjab.
Yes, sir. So certainly, so that is one thing. But sir, I'm sure that sir, There has been a recruitment, sir, in the year 2023, and certain batchmates of mine have been selected. So they are very sir, competitive, and they're very diligent. And I'm certain that so they will be taking care of the interests of Punjab. So that is uh, assured, sir.
All right. All right. So you did your clerkship at Supreme Court.
Yes, sir.
Yeah. So would you call it a diverse experience?
Yes, sir. Sir, we have, because sir, a judge would have a changing roster. So, sir, I got matters based on CPC, arbitration, evidence, criminal law. So, sir, it was a very diverse exposure.
So you broadly worked on, all kinds of matters in Supreme Court.
Yes, sir.
Okay. So when we talk about SLP, special leave petition under Article 136 of the Constitution India, so it says special leave to appeal, right? So what is the meaning of this leave to appeal?
Yes, sir. Sir, special leave to appeal is an application to the court that this should be granted. The Supreme Court should exercise its plenary power under Article 136 and accept the appeal rather than following the other procedure of taking certificate from the High Court and then approaching the Supreme Court. So, special leave to appeal is that a permission has been sought from the court. After the permission is sorted, so the number of the SLP is changed to regular appeal or regular civil appeal or regular criminal appeal. So once it's basically the litigant is seeking permission to the from the Supreme Court to directly approach the Supreme Court rather than going through other procedural matters.
Okay. And does every judgment from the Supreme Court would contain the phrase leave granted?
Sir, if it has been allowed, the permission has been granted, sir, then it starts with leave granted. Otherwise, sir, if it has been not admitted, sir, it will be dismissed by an oral order.
Okay. Can you explain it to me? What do you mean by doctrine of merger?
Yes, sir. So doctrine of merger is basically when when a particular judgment of the court has been appealed to a superior court and the superior court has disposed of, sir, then the judgment of the trial court gets merged into the judgment of the superior court. This is to prevent any kind of confusion or existence of multiple orders.
So let's suppose there's a High Court judgment, okay? Against that an SLP has been filed, but SLP has been dismissed by a standard order. That we have heard the parties, there's no ground to interfere under 136. So how in this case merger would apply?
Sir, in my opinion, sir, because the leave was not granted and at the very threshold the matter was not taken up, sir, I believe there is no doctrine of merger because there was no consideration on merits in this case. So therefore, the merger would not apply.
All right. Ayush, can you tell me about the difference between horizontal reservation and vertical reservation?
Sir, I would like to refresh my memory upon it. But sir, in my opinion, sir, the horizontal reservation is the vertical reservation is basis the communities that require reservation based on the social and economic backwardness or the historical suppression. Whereas horizontal reservation is amongst those communities if there are certain specific groups such as women, sports person who require special reservation. Within those particular communities, such special reservation is granted. However, sir, I'll have to revise my knowledge on the reservations.
No, I mean, you're broadly correct only. So, regarding arbitration, do you think arbitration regime has been successful enough?
Sir, I was reading an article where it was stated that how the even arbitrations are getting delayed. Sir, there are certain few factors that I would believe that can contribute into success of an arbitration regime. So first is we require a dedicated arbitration bar. Sir, unlike in other countries, sir, India does not have a dedicated arbitration bar. Most of the arbitrations begin after 5 p.m. when the courtrooms get over. Second is, sir, most of the arbitrations are taken up perhaps by retired judges or perhaps lawyers. So, sir, the craving for following the procedural law is somewhat there. So, therefore, sir, the principles that we should not follow strict procedures of law is usually not followed. And, sir, also the fact being that because of the interests of the parties, rather the parties which wish to delay the proceedings, sir, would engage into tactics even in arbitration to get the arbitration delayed. So, these are certain factors that are not that are hindering the success of arbitration regime.
Do you think basically the entire purpose is to have an out of court dispute resolution? But essentially, in arbitration, you have an award, then you have 34, then you have 37, then after that, you have SLP also, correct? So,
Yes.
don't you think, in a way, indirectly, another layer is being added along with the burden?
Sir, I would beg to differ on a certain aspect. Sir, in Section 34, the reappreciation cannot be on facts and evidence. There are only very limited reasoning that the courts can engage into, which is with regard to whether it's perverse on the face of record, and therefore it has to be on the face of record perverse. The court cannot go into merits. Secondly, sir, if it's public against the public policy of India, against most basic notions,
There's a limited interference that
very
you want.
limited, very limited interference. Therefore, sir, it's not another layer.
Just tell me something. Does Code of Civil Procedure applies in case of Arbitration Act?
Sir, there has been a dispute with regard to the application of Section 9, sir, when interim relief is sought. Sir, whether or not the strict principles of Order 38 Rule 5 will apply or not. So these are interim measures that are to be granted. So, sir, there are judgments by the Supreme Court. One states that strict principles of 38.5 will apply. One states that no, they will not apply. Sir, in my opinion, the very object of arbitration is to have much more party autonomous procedure based on commercial wisdom, and so strict principles of CPC should not apply.
And on what principle an arbitral award is enforced or executed?
Sir, once the arbitral award has been passed, sir, under Section 36, sir, it goes to the executing court, and the Order 21 starts being applied on CPC on execution of that arbitral award.
So strictly CPC then.
Yes.
Okay. In new BNSS, while I was reading somewhere, it's mentioned that, now you have to give a judgment within 30 to 45 days of conclusion of argument. Do you think it is feasible?
Sir, with an extension to so what you have stated, I also, sir, heard a particular judge stating that sometimes the number of witnesses, especially in conspiracy and terrorism cases, are more than 100. The evidence is voluminous. So, sir, it may be because, sir, it states that judgment hurried is judgment buried. So, sir, it may be practically difficult for the judge. But, sir, given the fact it's directory in nature under special circumstances, so the judge can take more time to deliver the judgment.
Ayush, just tell me, let's suppose you have a suit in your court, okay? Out of plaintiff and defendant, you know defendant because he used to live at your hometown sometime. You know him well, and in a way, you know that, entire family and the people back then, they're honest only. So, what is being alleged by the plaintiff against the defendant, whom you know, it's not correct. So, will it have any weight on your decision making?
Sir, in the Indian Evidence Act, now the Bharatiya Sakshya Adhiniyam, the character in a civil suit is irrelevant. So one is that. Secondly, sir, if I believe that the person is known to me, sir, my first duty, I believe, will be to let the other party know that this person, if he's a very close friend, that the other party is known to me. And if you wish to get the matter transferred, sir, I may recuse from the case if, in case my opinion may overwhelm my decision making.
All right. Just tell me the basic difference between Article 226 and 227.
Sir, Article 226 allows for the litigants to approach the High Court for 5 writs, whereas Article 227 is the general superintendence that the High Court exercises over the district judiciary.
So, any example of a proceeding filed under Article 227?
Sir, usually, sir, when the orders that are passed by the district courts, which though are not in violation of the constitutional law or any law, but sir, there is certain perversity with regard to that order. Sir, litigants go and file those orders, and sir, it's also a way litigants, because sir, the provision of revision has been restricted after the 2002 amendment. So litigants go approach the High Court in the 227, and therefore the High Court can appreciate an order of the civil court under 227.
What would be your 2-3 pointer strategy for effective case management?
Yes, sir. Sir, first is, sir, as sir stated, sir, we can have artificial intelligence, sir, which can schematize the matters which require more consideration basis the time, basis human rights violation and other equity considerations. Second is, sir, there was a proposal that we can have some professionals from the Indian Institutes of Management who can help assist judges in more administrative efficiency. And so last but not the least is basic facts that needs to be targeted is vacancy, support staff to the court, better infrastructure, which has already always been pointed out by the Supreme Court and has been stated to the executive.
My last question, can you differentiate between per incuriam and sub silentio?
Sir, per incuriam means that the judgment that has been delivered is in fact is not in correct consideration of the law and facts. Sir, sub silentio, I'll have to revise. I it was in my mind, but I'm unable to recall.
It's okay. Just one small question. Sometimes we ask the relief on the basis of equity. So, what is equity exactly?
So equity is that basis attending circumstances, even if the strict application of law would go against that particular party. So basis equity, we can grant some kind of concession to the party, knowing the circumstances were beyond control or what the attending circumstances of the case are. So we can grant some kind of concession out of discretion if the law allows.
All right. Thank you.
Ayush,
Yes, sir.
I want to know just now when sir asked you regarding Article 226 and 227, you said that once the order is passed, then a person can approach High Court or Supreme Court. Whether it is mandatory that order is to be passed, then only a person can approach High Court and Supreme Court, or during the pendency of the case also they can approach High Court and Supreme Court.
So during pendency, also if there are certain interlocutory or interim orders passed during the, so for example, if a question has been asked to the witness and the court has denied asking that question basis objection of the other party, even such orders can be challenged with the superior court.
Because they are under 226 and 227, regional jurisdiction is there. Okay, what is the difference between res judicata and res sub judice?
So res judicata is where a matter has already been adjudicated finally by the court, and the same is is based on same substantial issues and between the same parties. The court, once has been adjudicated, the court cannot reopen this particular matter. Res sub judice, on the other hand, is if the matter is already pending based on similar facts and same facts and substantial issues between the same parties, the other court cannot try that matter.
And what is the difference between bailable and non-bailable? Wow.
Sir, bailable and non-bailable has been classified in the Bharatiya Nagrik Suraksha Sanhita in its Schedule 1. Sir, bailable orders are those where the bail can be sought as a matter of right, whereas non-bailable offences are those offences where the granting of bail or not granting bail is a matter of discretion with the courts.